From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com. Richard Walton is joining us today. He's a trial lawyer and founding partner at the Marina del Rey, California law firm of Walton and Walton. He's tried hundreds of cases in both state and federal courts throughout the United States. Thanks for being with us today, Rich.
Real pleasure.
How long have you been practicing law, Rich?
Private practice since 2003, just department before that. Coming up on what my British friends would call a quarter of a century.
Can you describe what your current practice is in terms of the kinds of cases that you handle?
Yeah, I try cases. I'm one of two trial attorneys for our law firm. We have offices across the country, and if a case is going to trial, it's either going to be me or my partner, Bodie Bardleben, out of Alabama. He is, I hate to say it, a better trial attorney than I am, but sometimes the clients get stuck with me, and that's what I do. In terms of my own experience, sweet spot, caseload, I grew up with federal criminal cases and then did an LLM in taxation. I worked for a couple of years for the U.S. tax court, so any kind of federal or state civil or particularly criminal tax issue is just a real slow fastball over home plate for me. But if a case can be tried, I probably have tried it, and I'll certainly show up and try it for people.
Are there any particular practice areas that you tend to gravitate toward?
Very much, they say in terms of my own caseload, it would be federal criminal and civil. Criminal tax is just a particular love of mine. Any cases involving money, numbers, counting, in addition to being an attorney, a certified public accountant in Delaware, not in public practice. So anytime a case involves CPA, expert testimony, voluminous bank records, etc., that's an area of particular interest for me.
So you mentioned you have an LLM in taxation. What is it about tax that drew you in?
Just the chance initially to do something that really nobody else was doing. When I went to law school, I never thought I was going to practice a day in my life, and I really wanted to do constitutional law. When I got there, I had an absolutely wonderful tax professor, Martin Ginsburg. I took every class he taught and finally managed to get an A out of him on the last one, but I struggled hard to do it. Marty was just a prince of a guy that could absolutely sit there and recite the Internal Revenue Code from memory, but he was modest enough to hold up a book and pretend he was reading from it. His eyes had gotten to the point where if he didn't have his glasses on, half the time the book was upside down, but he didn't miss a stroke and really taught me to love tax law going through my JD program. And then they had a bit of trial and practice experience from Justice Department and private practice. I went back to work for the U.S. tax court as attorney advisor and decided to take Georgetown's LLM night program and got the Master of Laws in Taxation while I was there.
How many cases on average would you say that you try a year?
I tried 7 cases last year, which is 2 more than I probably do on average. Most of my cases are complex litigation. Some of my trials can take 6 months or more. So it just depends on what my availability is. But if I'm not in trial, there's usually somebody that's trying to put a trial on my calendar, so I just try as many as I can.
These days, 95% of cases never go to trial, and that's largely because of how expensive the attorney's fees are. Do you think that the efficiencies achieved through generative AI are going to bring the cost down enough so that more cases are resolved by trial?
That's a really good question, and I think there's a couple of different parts to it. Let me start with generative AI, which I don't personally use. There's a couple, 3 lawyers in my firm that were early adopters of it and quite fond of it. I gave them the same advice I give your listeners, which is whether it's a computer doing the research for you or an associate or your own research, if all you're doing is reading even a court of appeal opinion saying this is what the other case stood for and citing it, read the case you're citing before you cite it. One of the best pieces of advice I got from Justice Gilbert Naras when I went to work for him in California's 4th District Division I Court of Appeal was, kid, don't ever cite a case that you haven't actually read. We sometimes make that mistake, and then we go back and read the case and read what somebody else thought it said and read what it actually said, and they're two very different things. So my own experience with generative AI has been very limited. I will do sometimes just a Google search as opposed to Lexis or Westlaw if I'm looking for some background information. And the first thing that Google gives me now is an AI summary. And I do exactly with AI what I do with any research memo that an associate or partner gives me. And frankly, what I do when I'm doing my own research, I just keep drilling down until I get to the original source. I read it, I understand it, and I don't cite it or rely on it until I have actually done that. So I would say generative AI I think, has a tremendous amount of potential. I don't personally use it, and I'd encourage anybody who does to make sure that you're not just copying the summary. Make sure you read the underlying authority. As to what effect it's going to have on trials, I think it's like everything else we're doing. Technology is streamlining the process. When I started practicing, we still blew back to our federal filings and had to take them in by hand. Now we can do it electronically. Now we can appear in court electronically. Case management conferences that used to take 2 hours of driving and hour of sitting around the courtroom and a $30-$40 parking fee to be there. We can whistle in on the computer, get other things done, make our 5-minute appearance. Technology has allowed us to be much more focused and productive and efficient in what we're doing. I don't think it will ever completely replace what we do. I think it'll make it easier to do it. And certainly as the technology gets better, across the board, we're seeing less time needing to be spent on cases. I think the second part of your question is this: 90 to 95% of all civil cases settle before they get to trial. Criminal statistics are roughly 85 to 90% are pled out. I don't really have much to do with those cases. I get whistled in on the 5 to 15% that go to trial. But I will say this, in terms of how a case is worked up, as a trial attorney, I'm very focused on what I think I need to put in front of a jury. And that's very different from my civil litigation partners who tend to go out and get involved in a lot more discovery fights and looking for things that I just don't bother asking for because I don't believe they're going to be that important. That being said, the best lawyers I've ever worked with, including a couple of partners in my firm, I jokingly call them my catfish. They trundle along the bottom of the legal ocean and they do all their civil discovery and they fight over a bunch of stuff that I wouldn't necessarily have thought was important going into it. But sure enough, we get to trial and they've managed to dig up some nugget from all of that is tremendously helpful to me, to the client, to the outcome of the case. I'd say probably the best outcome for the client is having somebody that's really, really good with civil discovery that will track down every lead that might potentially be useful and then hand that over to a trial attorney who tries to summarize all that down to the 2, no more than 3 points that may be helpful to the finder of fact in resolving it. That's the most expensive approach, but it's certainly the most thorough, and it's the one that's designed to get the client every possible advantage from before the case is filed to your final jury verdict and any potential appellate outcomes after. I think lawyers that try cases for a living tend to be more surgical and focused in what they ask for and what they fight over. But by the same token, you never quite know until you're done exactly what little nugget of information might be helpful. So AI is in its infancy. Yes. Do you want to triple check everything it's telling you? Absolutely. Is it going to make the trials easier to get spun up? You bet you. Is that going to change the percentage of cases that go to trial? Probably not much from my perspective. I think most cases settle because clients want them to settle. Sometimes the cost that's gone into it factors into that. Frequently, in my experience, it doesn't. I think you'll probably end up seeing about the same settlement percentages versus trial. I just think you'll find it across the board should be being much cheaper for the client with the better technology we have available.
You co-founded Walton and Walton with your father, Lewis Walton. What's it like practicing law with your father?
Along with number of other people, all of whom are much smarter than me. I'll tell you, it's one of those things in terms of practicing with my dad that it's either going to be fantastically good or it's not going to work at all. When I left the government for the last time in 2005, I very quickly found myself having just far more work than I could do. I convinced my dad to come out of retirement in 2006. He and I have been together through 3 different law firms since then, and it's been the absolute highlight of my professional career, greatest pleasure and privilege I could have possibly had as an attorney has been practicing with my dad. Even though hearing us talk, you might not think we were that different. He and I come at problems in a very different way, and we analyze things very differently. And between the very different ways we approach it, I think the clients get a far better result. Frankly, as they always do when lawyers work collaboratively together, which is why I think what you're doing with your podcast is such a tremendous opportunity for the community to share collective knowledge and hopefully together get better and better results for our clients.
Thanks for saying that. I can just tell you it's a lot of fun. So, at what point in your education or career did you decide to make trying cases the focal point of your practice?
If it hadn't been for trying cases, I'd be back in finance doing what I was doing before I went to law school. I never intended to practice. I kind of got sucked into a first summer job and then a second summer job. And then I'm thinking, well, real lawyers should at least try a couple, 3 cases. And I tried a couple, 3 cases and discovered I absolutely loved doing it. And here I still am. So it would absolutely be the only reason that I'm actively practicing today.
Are you sometimes called into a case very near trial where you essentially have to parachute in for another attorney who had been handling the case up to that point?
Frequently, and when that happens organically and internally within the firm here, it's a lot easier than when it's an external referral. I'll tell you, the last 2 large cases that I tried were both external to the firm. The one that I just finished trying this year was coming out of New York. The prior counsel had been excused by the court from representing the client on a 5-year limit case, so we didn't have any room to move the trial date, nor was it wise to do so. So that one I got spun up on quickly, and the jury trial I did in San Francisco finished very late last year was literally called on Friday, and I was present and ready in San Francisco coming up from Orange County, where I was supposed to be in trial on Monday. I was hired on Friday, and I was starting trial in San Francisco on Monday. So I had about 2.5 days to get spun up on that one. And that's, in a lot of ways, is kind of an ideal circumstance for me because I don't have to worry about nasty letter writing or discovery motions or any of that. I just get to try the case and do what I love to do. And I don't know a ton of attorneys that when clients are looking for somebody crazy enough to take a case on with 2 days or 2 weeks or whatever to get ready are really arm wrestling me for the privilege. But the big thing that I've learned in trying a few cases over the years is you got to be able to assimilate whether you have 2 years, 2 months, or 2 weeks or 2 days to do it. You've got to be able to assimilate an enormous amount of information. You have to be able to pare all that down to what is important for the finder of fact, judge or jury to hear that will help them in resolving whatever the dispute is. And then you've got to apply the rules of evidence best you can to try to get your facts in and keep the other side's facts out. And that's a job that, like anything else in life, will expand to take as much time as you have to do it. Would I prefer to have 2 months as opposed to 2 weeks? Sure. 2 weeks is better than 2 days, but at the end of the day, it's a matter of sometimes not sleeping much. But if you can get the key points in your head, you can learn the case as you go. And frankly, I'll just add to that, Steve, that I think one of the biggest mistakes looking back that I saw myself make as a young lawyer was frankly over preparing the case. And I think too many lawyers sit there with a case for 2, 3 years and they script it in their head and they read all the law and they say, well, the law says it has to be this, therefore the facts have to be this. And they start wanting to try to prep their witnesses, this question and that question. And the end result is just a mess in front of the finder of fact, because the lawyer is tone deaf to things that are happening and being said, and that the jury or the judge is hearing and assimilating and understanding. The lawyer's not picking up on it because it's not tracking the script they've got in their head. The witnesses are confused to hell and gone. I very much am in favor now of a much more open-minded, exploratory process. There's an old saying that trial is the search for the truth, and I really believe that. I think if you walk into a case with a completely open mind, you listen to what all the witnesses are saying, and you adjust your legal strategy and your trial points that you want to get across to accommodate what's actually happening, as opposed to what you gamed out in your head and thought was going to happen and wanted to happen. I think you'll do a much better job for your clients. So I'll not only say that I don't mind taking cases on short notice, I think a lot of lawyers do themselves a disservice by over-preparing their case to the point where they're just not hearing what's actually happening, if that makes sense.
Do you have an established workflow that you've adopted to get up to speed quickly when you parachute in a case like that?
Absolutely. You just triage what has to be done first. If I've still got time for motions in limine, which sometimes I don't, particularly in LA Superior, where they've got to be done on normal noticed motion. That's the first thing that we whip up. After that, the next thing that I want to know is my exhibit list, my witness list. If it's a case that I'm just coming in on, I want to sit down with the lawyer that's giving it to me, if there is one. I want to talk to the client. I want to start interviewing witnesses. I want to figure out what they're going to say. Next thing I want to do is figure out what my exhibits are, and those are frequently two parallel tracks, which is figure out your witnesses, figure out your exhibits. The two absolutely go hand in hand. And once I get my exhibit binders done, that really is the universe of what's going to be coming into trial, factoring out, obviously, impeachment or rebuttal exhibits, of which I usually have a couple of binders worth, depending on how things go. And then the next thing I've got to get for a jury trial is jury instructions and verdict form. Verdict form and jury instructions are critically important. If I had a nickel for every time I've seen a lawyer that doesn't try a lot of cases walk in with, well, I got all the important stuff done, I've got my trial brief, and I've researched the law, and I understand the law. The law's got nothing to do with the trial until much further on in the process. Trials are storytelling, and I want to know what the story is. I'll figure out the legal significance as I go. I'll have associates researching the legal significance and giving me memos, but I absolutely want to know what the story is I'm telling. And part of getting that done is getting your jury instructions and your verdict form done and done ahead of time. Guaranteed your verdict form and your instructions are going to change somewhat as the trial progresses, but I'd say the biggest mistake I see lawyers make that don't try cases for a living is putting off the instructions on the verdict form, because those instructions in that verdict form are, number one, the law the jury is going to get for the case, not your research. It's going to be those cases, or in federal court, your Ninth Circuit model jury instructions. And the verdict form is the questions they have to answer. And if you're not reading that verdict form in the morning when you're waiting for the jury to come in, if you're not reading it when you get home at night and trying to figure out what factually happened that day that helps or hurts how the jury is going to be answering those questions, you're probably missing some of the more important parts of what you ought to be focused on.
I'm going to ask you some questions now about voir dire. So for our listeners, can you explain what voir dire is?
Sure. Single best chance you've got to tell the jury what the case is about. Again, in very generic terms, you can't be too specific. It's the only opportunity you have to interact with jurors, hear what they think, figure out their personalities, figure out who you may want to be more focused on and how you want to be saying things. I'll come back to that thought in a moment. It's the jury's chance to get to know you and get to know your case. It's probably one of the most important parts of that trial. Because if you do your job right in voir dire, the jury ought to have already a pretty good sense in their gut as to which way they want to go with the case. And that little footnote I promised you, I will just say that getting to speak with jurors, getting to understand their background, how they process information is incredibly important, because there's no one single way that I can say the same thing and have 12 different people hear it the same way. Some of them are going to hear one part of what I'm saying. Others are going to hear another part. Some are going to be very focused on the evidence and the facts. Others are going to be focused on the feelings. How do they feel about the case? And if I'm not trying to present the case that I have to present in different ways for my different jurors, and knowing which jurors those are, and keep an eye on them when I'm trying to present feelings as opposed to hard evidence, again, I'm missing one of the more important parts of the advocacy process, which is absolutely interactive. When you're trying a case, you're not pontificating, you're teaching, you're educating. Voir dire is your chance to know your classroom, know who your students are, and try to figure out the best way you possibly can to educate each one of those jurors on what you want them to know, hear, experience, see, and feel.
How useful is it in your experience to do focus groups or mock trials in order to get a sense of the kind of juror that you want?
Incredibly. In terms of spending enormous amounts of money on it, I have tried cases for Fortune 50 companies where budget was absolutely no problem whatsoever, and they've spent six figures on that process. Did I learn much of anything out of it beyond what I could get just going out into the community where the case was going to be tried? Go to a restaurant. If you don't mind going to bars or pool halls, just meet people, talk to people, tell them a little bit about what the case is, ask them what they think. And then obviously, as you meet some folk that would be interested, give them $100 or $200 in cash to sit there and listen to you and another attorney on your team present both sides of the case. I think that's an incredibly helpful thing to do, but I've also found that it can be done for a much smaller budget than what I've seen some clients spend on it. Teaching me something as the guy trying the case, I haven't learned anything more from expert consultants that we paid hundreds of thousands of dollars for that than I did from just rounding up an average group of folk and running through what the issues and the arguments might be.
So in your opinion, the intuitive method of formulating a profile is just as accurate and valid as something maybe based on statistical evidence or data?
Yeah, and there's a couple reasons for that, and I'll caveat that with a short story at the end. We don't get to pick our juries, point number one. We don't. We get a chance to deselect 6 jurors that we don't want on there. The other side has absolutely the same opportunities that we do. And generally, if it's a juror that we want, the other side, if they're thinking, probably doesn't. And if it's somebody they want, we probably don't want them. So the practical end result of all the jury study and the statistical data and voting records and this, that, and the other thing is, at the end of the day, you're going to end up with a jury of 12 if you're in state court, plus 2 to 4 to 6 or more alternates, depending on the length of your trial. And those are going to be the people that everybody ended up with. It's not necessarily the jury you wanted, but it's the jury you get. So I've worked with some really fine jury consultants, and I don't in any stretch of the imagination mean to diminish what they do. If you don't have an enormous amount of trial experience, or even if you do, they absolutely bring valuable data to the table up to a point. and this is my second point to your listeners, which is juries decide cases based on how they feel about them at the end of the day. And you will sometimes get questions. Sometimes they'll look through evidence. Frequently they will. I've never seen a jury that I didn't think really put in the time and tried to come up with what they felt was a fair result. What I think a lot of people miss is that juries make those decisions based, in my experience, on how they felt about the case when it was submitted to them. And jurors sometimes will have very strong feelings one way for me, sometimes others will have strong feelings against me. And the only time they're wanting readbacks or they're looking at evidence is when they're trying to convince the other jurors that their feelings about the case are incorrect. So that being my experience with how juries decide cases, I personally don't spend any time looking at how they voted or the tremendous amount of incredibly useful data that a jury consultant can give you. I'll let one of my partners or one of my associates sift through all that. I'm looking at the jurors. I'm seeing how I feel about them, because it's feelings in a courtroom that ultimately, in my experience, drive the final result.
When you're representing a corporate client, for example, do you try to humanize them to the jury?
To some extent, yes. I think it's very important to have a client rep sitting there so that the jury can look at a human being as opposed to just the nebulous idea of XYZ megacorp. By the same token, I also rely heavily on the cases. The law simply is that a entity party is entitled to no greater or less consideration than an individual. And I do try to humanize the client to the maximum extent that I credibly can. By the same token, I don't want to be corny about it. I mean, if you're representing a large defendant, you're representing a large defendant, and you just have to recognize that fact and humanize them without losing the jury by trying to over-humanize them, if that makes sense.
Through what techniques do you use to humanize your client?
Particularly if they're a local defendant, we want to talk a lot about how important they are in the community, how long they've been in the community, what they've done for the community. If, for instance, it's a hospital with excellent ratings that people go to all the time, particularly if it's a company that I use or somebody in my family, preferably somebody in my family has used, I have no problem telling the jury things like that. I tried a case a couple of years back for a big hospital, and my grandmother had actually gone there, and that hospital had saved her life. I think that's a very important fact for a jury. Well, it's an argument. If I'm saying it, it's not a fact, but it's certainly a feeling and an emotion and a fact in my life, even though it's just argument for the jury's deliberation, that this is a hospital that's done an enormous amount of good in the community. My grandmother wouldn't have lived into her 80s if it hadn't been for them. And when I'm trying to humanize a client, I try to focus on the good that they're doing in the community and the good they're doing for others. And if there's any way that I can reference something personal to my family, I always think that's a good idea, because guaranteed, if you had a positive or frankly negative experience with the large corporate defendant, you're going to have other people on that jury who have been through exactly the same good or bad feelings for themselves or their family. That's inevitable.
How important do you feel it is to let the jury know that you're sensitive to the fact that they're taking very valuable time out of their lives to be a juror?
I think it's a nice thing to say somewhere along the way. I'm not as fond of what I see a lot of attorneys do, where they want to get up in the first 5 or 10 minutes of their closing argument is talking about the magnificence of jury service and what a wonderful, important civic function they've served. And again, a lot of lawyers do that, and I've seen it. I've seen those lawyers get effective results for their clients. My experience is that, particularly after having sat through a 2-week, 2-month, 8-month trial, the jury knows that case backwards and forwards, heard everybody get up and hem and haw and say the same thing 5 different ways and ask the question 20 different times to 10 different witnesses. they've got a good sense of it. And I think juries are looking for the lawyer to tie it together for them and quickly get to the point of how everything they heard leads to a result one way or the other. My own feeling on it is that if you are waiting 5 or 10 or 15 minutes to get to the merits of the case while you're telling the jury how important they are and how important jury service is and Abraham Lincoln and the beauty of the law, they're expecting right up front the best you've got. And if that's the best you've got, my experience with human nature is they tend to start to tune you out because they don't really need all that. What they need to know is how to decide the case and how all the evidence they've heard may or may not be helpful or harmful to your client or the other side. I tend to try to front load the important arguments right up front. And I don't think magnificence of the law and the importance of jury service is in any way important to the jury to resolve the case. I think it's important to get around to it at some point. But let me put it to you this way. I have closed cases where I never once mentioned it. Usually I do, but I don't think it's absolutely necessary or sometimes even advisable.
Do you think that juries resent it when trial counsel takes too much time?
Absolutely. Absolutely. Anybody who's tried more than 5 jury cases can walk into any courtroom, any given day ending on why that the court's in session, and you look at a jury that's been in a case for long enough that they've heard every single theory the lawyers have, and lawyers being lawyers tend to always want to keep arguing the same thing and making the same points. And you can walk into a courtroom and look at that jury and if the trial attorney ever wanted to ask my opinion, I'd say, brother, stick a fork in them. They are done. Sit down, shut up, get on with your case. Because at this point, you're just irritating them by continuing to tell them stuff they already know. And that's just feeling. I couldn't put that in a textbook. I couldn't tell your listeners, here's specific things that you look for. I mean, there's certainly some. In terms of how a jury is reacting to you, but it really does come back to my comment. It's an iterative teaching process. If they're not paying attention, if they're bored, you're either not doing something that they consider as important, or you're not presenting something that is important in a way that they're understanding why it's important. So pay attention to your audience, and when they've got it, do yourself a favor and sit down and let them go do what they're there to do. They're not loving sitting there hearing the same thing said 40 different ways.
What general advice do you have to new lawyers who want to make a career as a trial lawyer?
3 simple rules. Keep it short and simple. Number 2, keep it accurate. Don't ever let a judge or a jury look at something you said and say, said that, but I heard the evidence and you're just wrong. And in court, they don't necessarily think you're wrong. They think you're lying to them. Don't make that mistake. Keep it short and simple, number 1. Number 2, keep it accurate. Number 3, make it count. Law school is the worst, and I mean the absolute worst, at teaching people how to express themselves in short, concise, meaningful ways. It just inevitably pushes us into passive voice, using 30 words when 4 or 5 would elegantly suffice. Rich's 3 rules of trying cases: keep it short and simple, keep it accurate, make it count.
Do you think the crushing student loan burden that most law students face limit their ability to take jobs that might give them trial experience early on?
It shouldn't. I remember when I graduated, there were a lot of programs where you could get student loan forgiveness or deferral, at least for federally backed loans. And even though I do teach law students these days, I'm embarrassed to say that I don't know exactly what the state of all that is at the moment. And to the extent that there's not a program out there that allows students to take jobs as assistant district attorneys, deputy public defenders, federal public defenders, assistant U.S. attorneys, trial attorneys for the government, they're just really not doing what they should be doing for the legal profession, because the sad reality of it is the only way these days, and frankly, the only way really ever to get trial experience, was to work for the government. Most forgiving client in the world, right? You lose a case, everybody has a chuckle and says, yeah, the kid learned something, and he or she will do better next time. That is just not possible in private practice, where for risk management reasons, the last thing that a law firm wants to do or will do is to put a kid in when you've got an attorney that's got 100 plus trials under their belt. If the firm loses, they'd a whole lot rather lose with somebody like me trying the case. That just mitigates E&O exposure for them. So absolutely any law student that wants to get trial experience, I think there should be a path to do that. There used to be. I tremendously hope that our current loan programs will make that possible. And if they don't, that's certainly something that should be looked at, because there's just no better job on earth than trying criminal cases on both sides of the courtroom. You learn an enormous amount about how to do the job, and it's very, very hard to replicate that most anywhere else. House them over in my firm, we try to find a low value case and let our young associates get in there and try them. I'll second chair for kids in the firm that haven't tried more than one or two cases or zero cases before, and just be there as a resource for them. But you got to find a case where if the firm loses, we're not looking at massive exposure. If the client comes back and says, well, gee, Rich, why weren't you the guy trying the case? Or, oh, why weren't you trying the case instead of Rich or the young associate?
I'm probably not the first person to ask you this, but have you ever asked that one question too many?
Oh, sure. Not in every trial, thank God. And the more I do it, hopefully the less I do that. But I'll tell you a funny instance of that. I had a trial actually in Los Angeles Superior Court, and it was a bunch of celebrities, just one after the other on the stand. And one of the guys was Mr. October, Reggie Jackson. And he walks in, he's signing autographs for the jury, blah, blah, blah. And he had been really good friends with my client. So, of course, based on my understanding, I had him on the stand, and I figured, well, I should just ask him what he thinks of my client's character, because part of this came down to the credibility of my client versus the other side. He looks at me, he says, I don't want to answer that question. I said, well, I think you should. And back to my point of, don't get your own script stuck in your head to the point where you're not looking at and listening to the witnesses on the stand. This was a case that we had waited about 3.5 years to actually try. So I had gotten it ready to the point where I frankly knew the case too well. And I forced Mr. Jackson to answer that question. He said, I really wish you hadn't forced me to do that, because there was a time he was my best friend, but these days I think he's a dishonest crook. And I went, oh boy, I really didn't want to do that, but there you go. We won the case, incidentally, despite Reggie's best efforts, but he did not want to say something bad about my guy, and I absolutely, like an idiot, put him into a circumstance where he did. That's all public record, so I can disclose one of many instances where I said to myself, yeah, I shouldn't have done that.
So you struck out on that one?
We won the case. I struck out on that question.
Thank you again for joining us today. Can you tell our listeners the best way to get in touch with you, Rich?
Sure. Other than calling you, Steve, because I can't think of an attorney that I would refer them to other than you when it comes to labor and employment law. But something beyond that, they're always free to either call my direct line, 310-363-7321, or email. It's a little long. It is rwalton, WALTON, T as in Tango, at taxtriallawyers.com.
Thanks again for being with us, Rich.
Steve, thank you. And on that note, I just want to say that I think what you're doing here is such a tremendously valuable thing for your listeners, whether you're a partner in a national or international law firm or a solo practitioner, law student, whoever you may be.
Well, I appreciate those words, Rich. Thank you again.
Always a pleasure, Steve. Have a great afternoon.